Wisconsin. Jim is a Milwaukee native who went to Marquette University, where I first had the pleasure of meeting this extremely bright and dedicated individual. Attorney Santelle went on, attended the University of Chicago Law School, clerked for Judge Warren in the Eastern District, and then began his career in the US District Attorney's Office for the Eastern District. He also served some time as well for the United States in the Iraq War as rule of law coordinator and legal advisor at the United States Embassy in Baghdad. In 2009, Jim was nominated by then President Barack Obama to be the United States District Attorney for the Eastern District of Wisconsin, where he was confirmed by the US Senate and began his service. He retired in 2015. Jim has been a frequent speaker at various community events around. I've heard him speak many times, and he's wonderful at cutting to the heart of legal matters and explaining what are otherwise technical matters that might sometimes go above the heads of non-lawyers. Tonight, Jim is going to speak to us on First Amendment issues.
Ahmed, I thank you so very much for that kind and generous invitation and introduction tonight. I am delighted to be with all of you this evening and appreciated so very much the invitation from the Taking a Faithful Stand for Equity affiliation, from the Interfaith Conference of Greater Milwaukee, from the Creating the Beloved Community Group, and others to be with you tonight. I will tell you that when those invitations first came out and we chatted a long time ago about the subject matter of discussion tonight, we decided on doing something that would be the least controversial thing that we'd possibly do on a mid-March Tuesday evening. So we chose religion and speech, and we'll see if we can live up to that commitment quite literally with my tongue planted firmly in my cheek. I will say that as we approach the subject matter tonight, and very much mindful of Pastor Michelle's entreaty, wondering when the inequities and challenges for truth and equity and nonviolence, when we begin to visit those, they will reverberate very much in the next 20, 25 minutes or so as we chat about the First Amendment. And I should also tell you that when it comes to these kinds of issues, as Ahmed and I and others of you who are also lawyers who have taken law classes, or even if you haven't taken law classes, appreciate fully, things we're talking about tonight could easily consume at least a half a semester, if not an entire semester, of any legal class. And for that reason, what you're about to hear and what you're about to engage with me on is necessarily quite superficial. And that's the reason why we have, as David said at the outset, I'll reserve some time for questions and answers, and hopefully we'll get to those as well. Delighted not only to make the PowerPoint available to you afterwards, but I know that the groups sponsoring tonight's program are also recording this for those who might want to review it again or see it in the first instance. So once again, as we begin this important discussion, a timely discussion about religion, and in particular, the First Amendment in our nation, we're very mindful of the fact that this looms large. And one of the things that you're going to hear during the course of this time as we discuss the First Amendment to the Constitution is this notion that reasonable people can in fact disagree. It's one of those areas where there can be reasonable views on, if you will, 2, 3, 4 sides of this particular issue. You'll also find that the law and the guidance from our Supreme Court and from lawyers and judges generally is not entirely clear. It has been changing, it has been conflicting, and it is somewhat muddled even to this day in early 2023. It definitely evolves and continues to evolve even in this term of the United States Supreme Court. And we're going to chat about what the Supreme Court is going to be addressing in this term, a decision probably coming up in just a couple of months near the end of our program. And so with that, we begin with the First Amendment, the commitment made by James Madison to people like George Mason, who were upset that the Constitution did not have these basic rights in its text when it was originally passed. made the commitment that the first Congress would take this up, and indeed they did. And note that the First Amendment, words that you all know well, the very first words of the First Amendment: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That language is going to animate all that we discussed tonight. As an important footnote, note as well that the word Congress has been interpreted to mean government generally, and doesn't include private institutions for the most part, but Congress interpreted to mean government, whether it's local, state, federal government, can also include school boards, can also include other entities that take their tax dollars or take their life and livelihood from public institutions and from the public force that you give them. And once again, the two fundamental lines, the two fundamental sets of language in that, the government will not in fact establish a religion. That often viewed as the fundamental notion of the idea behind separation of church and state. And second, your government also commissioned by James Madison and others to not engage in activities and events that prohibit your free exercise of your faith, whatever that may be. And so with that, let's begin to talk about how that language has been interpreted, not throughout the entire time of the Supreme Court, but principally getting a lot of important impetus for our present understanding in the 1960s. And you have heard many of these fundamental notions, and I've got them up there on the screen. There are many other cases out there that precede the 1960s, but in the lifetimes of, I suspect, a few of us gathered here tonight, you will note very well that the Supreme Court in 1962 said that because of this notion that government should not be intruding into religion, and religion should not be intruding into government, both of those things, a separation of church and state, in this case called Engel versus Vitale, finding that the daily compelled reading of a non-denominational prayer in public schools violates the Establishment Clause, would be government basically imposing upon people, again, in a public arena, a public forum, students, the obligation to engage in prayer. One of the important things that people misunderstand about that fundamental notion, and you hear this a lot as well, we all recall back in the 60s when the Supreme Court and government generally forbade the recitation of prayers in school. That is not what that case says. You can, and I suspect children and teachers and others pray all the time in school, not only in advance of algebra tests and in other challenges, but you can do that privately. The notion is it cannot be sponsored by a teacher standing up in front of the class, otherwise organized by a supervisor in that setting. Likewise, same kind of thing. No compelled reading of the Bible, and also interpreted to include other holy scriptures of other faiths. No public compelled reading in public classrooms, violative also of the First Amendment, also the 14th Amendment related to equal protection, that in 1963. And again, can you read the Torah? Can you read the Quran? Absolutely. And you can do that in the privacy of your own time, in your classroom, in your study hall, other times during the course of your time in school. What you cannot do is have a teacher compel the reading of those kinds of scriptural texts in that academic setting. And finally, this also I find interesting, 1968, in the state of Arkansas trying to rid science, if you will, from the public curriculum there, and saying that attempt to limit the teaching of evolution, presumably and placing that with a sort of a creation story coming perhaps from a faith-based text, that also violating the Establishment Clause that again prohibits Congress, prohibits government from intruding into your own personal sense of religiosity, of faith, and your own exercise of religion. That's just a very, very brief description of those kind of seminal cases. And so one of the things that you should understand tonight, perhaps at the start here, is this fundamental notion that coming out of those cases is something called the Lemon Test. And no, it doesn't relate to cars or something that your brother-in-law bought for you for your graduation from high school. It comes from a 1971 case of the Supreme Court and said basically, when we determine whether or not the government is intruding inappropriately, whether or not your freedom to exercise your own religion, whether that is being impinged in some way,
they ask fundamentally three questions. Does the statute, does the thing the government is doing, does the legislation in some way accomplish a primarily secular purpose? And again, secular purpose denoting some attitudes, some activities, or other matters with no religious or spiritual basis. Does the statute have some purpose that is not religiously related? Second, is its principal effect neither to promote or inhibit, advance, or in some way stop the exercise of religion? We want to be completely neutral, kind of down the middle. And third, we want to avoid excessive entanglements between government and freedom of religion. And those three principles have guided us until last summer, believe it or not, in addressing this important issue of how the First Amendment affects our lives. Secularity of purpose, neither aiding nor inhibiting the religious exercise, and excessive entanglements. Those three things, the Lemon Test from 1971, survived until 2022, and we'll get to that in just a moment or so. And so, consistent with one of my first points, you will see that over the course of the following years, the United States Supreme Court has applied this Lemon Test in a variety of different areas, in areas where reasonable people can disagree. And I suspect that as you hear some of these, you'll say, well, gee, that doesn't make sense to me. Why would it fall on this side of the line as opposed to this side? And the answer is there are judgment calls that are being made. And you'll see, for example, one case coming out of Wisconsin having to do with our Amish colleagues and friends and citizens, saying that the state requirement in the state of Wisconsin that compels every student to remain in school until the age of 16, the free exercise of the Amish population outweighs that. And so the Amish population permitted to remove, if you will, their own young people from the official public schools and teach them on their own. That's Wisconsin versus Yoder, a seminal case in this area. Then look at this one, Stone versus Graham, 1980, when the Ten Commandments appears in the public school indoors, which seems to be a significant issue here. That is violative of the First Amendment. Again, somehow a mixing, if you will, a non-separation of church and state, case called Stone versus Graham. And then look at this one, having to do with things you recall, even from recent times, Lynch versus Donnelly, 1984, not violated by having a nativity scene of the sort you see there on the left side of your screen in a public park, again, outside, but then also County of Allegheny versus ACLU, the same kind of thing, and a religious banner inside a courthouse. That is not permissible, okay? But that same display that includes a Christmas tree, a menorah, the kind of thing you see on the right side of your screen, along with a Liberty banner that kind of has a non-secular approach to it as well, that is permitted. And so all these things, Supreme Court wrestling, making lots of distinctions here, the kinds of things, again, if we had lots of time, we would parse through. Just last year, we were on the notion that the Supreme Court is really focusing a huge amount on religious issues was underscored from its review and decisions in 1, 2, 3, maybe 4 major cases. And I'm going to recite those for you right now, not only to underscore this important focus that the Supreme Court is making right now on the First Amendment, religious liberties, the Establishment Clause, the Free Exercise Clause. They are very much interested in this. And as those of you who are lawyers know well, we know that is that the Supreme Court does not have to take, is not obliged to take every appeal that comes up from the lower courts, typically the federal appeals courts, but not always. And so when they pick and choose cases, as they've done in the past year and again in this term, they're choosing cases where they have something to say. And indeed, in this case called Shultz versus Boston, they did have something to say. The basic background of this is the city of Boston. You see the picture there. That's the City Hall in the city of Boston. And on a regular basis, they have 3 flagpoles. One of them carries the flag of the Commonwealth of Massachusetts, another one typically of the city of Boston, and a third one is an opportunity for other groups, civic groups, to fly their flag. And all you need to do is you need to apply, you submit an application, and you say that I want to fly my flag for a week on this flagpole of the city of Boston. And what happens is a group called Camp Constitution, it sounds very, very patriotic, and indeed they are, but they do promote a Christian view of things. They promote candidates, they promote the accomplishments of Christians in Boston, and they come along and they say, we would like to fly our flag on one of these poles in front of the Boston City Hall. And the Boston city officials look at that and they say, you know what? That's a violation of church and state. That would be a violation of the Establishment Clause. That would be us as government and not inhibiting, but in some way promoting religion. And for that reason, they deny the request. The flag cannot fly from Camp Constitution. And they make that finding that you see on the second bullet point there, that the Supreme Court eventually does. Then indeed, that kind of thing, that distinction between purely civic and social groups and religious groups cannot stand. And the Supreme Court says, I'll read it out loud, the city cannot generally open its flag to flags from those groups while excluding otherwise similar groups with religion. That's Shurtleff versus Boston. And it underscores, it introduces this concept, which we see in a lot of the Supreme Court cases, that focuses upon discrimination as opposed to pure separation of powers. If you are doing something that affirmatively discriminates against a religious group or a faith group, that the Supreme Court more and more is finding violative of the First Amendment. Here's another one that does not specifically fall within the First Amendment, but it's interesting because, once again, Supreme Court took this case up, Ramirez versus Collier. That's Mr. Collier. He is convicted of a brutal murder in Texas, sentenced to death under the Texas capital punishment provisions. He wants his pastor to lay hands on him and pray with him in the execution chamber. And after that request was initially denied, the case goes up through appeals courts, and ultimately the Supreme Court says, you know what? Even in his last moments on the face of this planet, Mr. Ramirez does in fact have that religious right. He has got his right in particular under a statute, not so much the Constitution, called the Religious Land Use and Institutionalized Persons Act. He can in fact do this, and it doesn't so burden government but does in the religious exercise, and the state is not in fact using the least restrictive way of addressing and balancing these two things. And so the Supreme Court says, no, Texas, you've got to permit his pastor, his minister, to lay hands on him and pray with him, quite literally, as he is about to be executed. The difficult part of this story is that indeed Texas did that, but on October 5th, Mr. Ramirez was in fact executed, again, in the exhibition in his last moments of his religious liberties there in Texas. Here's the other one that has gotten a lot of attention, and one of the two major cases from just this past, the state of Maine. Many of you know, beautiful, beautiful state, but also very remote in some areas. And one of the challenges of education in Maine is that there's areas where the public schools do not exist. And so the Maine legislature comes along many years ago and they say, if in fact there are parents who want their students educated, and you do not want to take them 200 and 300 miles away every single morning to attend public schools in more populated areas, we will give you basically subsidies, scholarships, monies, so that you can attend those private schools in the areas where we do not have public schools. The only prohibition, Maine says, is that those private schools cannot include religious instruction. And they justify this on the basis that doing so, giving tax dollars, government dollars for this purpose, basically supporting religious schools, would run afoul of the Establishment Clause, the intermixing of government with religion, and that can't happen. Families come along and say, well, gee, that seems to discriminate against us. We'd like to send our sons, our daughters, our young people to schools, and including one of a religious nature. But by doing this, you're prohibiting us from doing that, and also along the way, prohibiting us from educating our young people. And so the Supreme Court gets a hold of this. And in 2022, that man, the Chief Justice, his name is John Roberts, in this case called Carson versus Macon, just last year, says indeed that Maine, you're wrong about that. That the direct benefit program, which private citizens receive benefits from, that age religious schools is frankly entirely permissible. And there is a choice going on here. There is a genuine independent choice, he says. And this practice of permitting government monies to support students going to private religious schools does not, in fact, run afoul of the First Amendment. No problem with separation of church and state there. And indeed, if you do what Maine does, and here it is, you are discriminating against religion in that setting. He makes reference to an earlier case a couple of years ago, finding the same kind of thing. Sponsored scholarships, state monies that support students attending private schools have to be extended also to religious institutions. Why? Because that's the free exercise of religion, not overcome by an establishment clause notion. Sonia Sotomayor, who we'll see again in just a moment or so, and other justices disagree vehemently with this. A statute, she says, subsidizing religious indoctrination with taxpayer dollars continues to dismantle the wall that has been set up for many, many years between church and state. That's Carson versus Macon, one of two huge cases just from last June, defining once again what the First Amendment means today. Here's the other one that you will certainly recall as well. It has to do with what happens every night, every Friday night anyway, football games and played in front of not only parents, but obviously other members of the community. This case, you may recall well, you've got a high school coach, and the facts here are somewhat unclear just because the record is somewhat unclear, but over time, this particular coach has the practice at the end of a football game of going out on the 50-yard line and praying, okay? And over time, what happens is what happens in that picture, what you see right there. His teammates the members of his team gather around him, and together they all pray in this very public setting, in a public high school, the prayer gatherings. And what happens is the high school initially says, you know what, we can't have you doing that. That's an intrusion between church and state. That's basically the state, virtually the school, establishing a religion and really compelling prayer in that very public setting. As a result of some back and forth, coach is ultimately fired. He really resigns, but he brings a lawsuit and says, you know what, this violates my right to free exercise in America, and my right to free exercise is not undermined or otherwise secondary to the Establishment Clause of the Constitution. And sure enough, what happens in this case called Kennedy versus Bremerton School District, and yes, it's Coach Kennedy, the Ninth Circuit first affirms the lower court that says that Mr. Kennedy, Coach Kennedy, made his own decision to intertwine religion with football. One of the significant appeals court judges, before it gets to the Supreme Court, kind of signals what the Supreme Court's going to do. He says, you know what, teachers do not shed their First Amendment protections at the schoolhouse gate. A major case called Tinker, those of you who know about the rights of students and teachers, still First Amendment rights in the schoolhouse, recognize that. Ninth Circuit case is appealed to the United States Supreme Court. And once again, by a 6-3 majority, that man in the top right, Neil Gorsuch, comes along and he says that the Establishment Clause does not make it necessary for government to be hostile to religion in this way. And here's the real controversial part of his decision. He says, this coach offered a short, private, personal prayer while his students were otherwise occupied. And needless to say, this gets the attention of many people because that's not really what happened here. But along the way, this is one more case where the Supreme Court, in looking at all of these religious cases, says your right to exercise your faith in this very public setting is not overtaken by the Establishment Clause. And Coach Kennedy, you can do just this. Once again, you've got Supreme Court justices, including Sotomayor, who's at the lower right hand. She says, once again, it ignores the history in this case, but goes on to decry this, as she describes, a path paying exclusive attention to the Free Exercise Clause while giving short shrift to the state establishment of religion principles that have animated things to this point. And so what happened is that as a result of that last case in Kennedy, there is this view now that we see in many other cases as well, that we no longer look to the Lemon test that I described just a few moments ago, that asks about entanglements, asks about secular purposes of statutes, asks about the balancing that's got to go on. The Supreme Court has all but abandoned, as of just last June, the Lemon test. And instead what they do, they now look to history. And they say, well, what is the history of the First Amendment? A very big question to ask. Significantly, those of you, and I know all of you do follow these issues when it comes to the decision in Dobbs on abortion, Likewise, a review of history, whether or not there was a privacy right under the Constitution. A case called Bruin, also from the same term last June, about whether or not guns in America, where you have a right to carry guns in a public setting. There too, the decision as authored by Justice, by all the justices, but Justice Thomas authors the principal majority opinion, looks back to history and says, what does history tell us as opposed to a present day analysis? And so once again, Justice Sotomayor says, you know what? You're overruling this long-standing test that does this balancing, and you're calling into question many, many of these precedents that we talked about, including those things from the 1960s and 1970s. A huge shift just about 10 months ago in our jurisprudence and understanding of how the Supreme Court operates. And there they are. Since that time, this is the new Constitution of the Supreme Court. As you see, Justice Ketanji Brown Jackson in the right back there, she has taken the oath of office, and she now joins the other Supreme Court justices there. And what are they doing now this term? Well, this as well. This is a case that has been up and back to the United States Court and may in fact be there once again at some point in the future. Very, very briefly, this is Yeshiva University in New York City. There is an LGBT group that organizes itself, and the university maintains that because it is a religious entity, that it can and does in fact shut down the organization, its activities. The group appeals, and if this goes up through the New York courts, goes up to the Supreme Court, and they did sort of an unusual, said, you know what, right now we're not going to vacate, we're not going to overturn the lower court New York decision that said, yes, the students do have this right to organize, even inside a religious university. But we're going to send this back because the university has not exhausted, not reviewed all the possibilities there. And indeed, this case is still pending in some way, shape, or form in the New York courts to determine which way this is going to go. Along the way, you also see that Yeshiva University responded to this interim decision that was not in its favor by canceling all student groups. And then the LGBT group came back and said, well, we're going to withdraw our application so these other groups can go forward. There's a whole lot more history here. But once again, this case, remember this, probably going to come back to the Supreme Court at some point. Again, wrestling, state courts, federal courts, wrestling with, again, in this area of LGBT rights and this issue of whether or not that inside a religious institution can in fact overcome the prohibitions of that university. Lots of focus on the nature of Yeshiva University as well, and their acceptance of some dollars as a non-sectarian group, another issue that's come out of this. And then here's the other big lawsuit, the big case that's pending right now before the Supreme Court. And you've seen a variation of this on the past. This case also coming out of the state of Colorado. Very simply, you've got a website designer. When you get married these days, one of the apparently obligatory things to do is you establish your own website that includes not only where you've registered for gifts, but also tells you all of the week or of the weekend. And so this particular website producer says that because of her religion, she is not going to provide services, her website services, to couples who are same-sex in nature. And she is arguably in violation of Colorado law that says that it prohibits businesses from denying commercial services to anyone based upon their sexual orientation, and that the law also prevents them from advertising their prohibitions, their refusal to contract with LGBTQ clients. The company is called 303 Creative, challenges that and says, you know what? That is a violation. The enforcement of the Colorado state law is a violation of my right to exercise my religion and my beliefs, and government cannot come in and do this. And indeed, the 10th Circuit comes back again before this goes up to the Court of Appeals and says that rules in favor of the state and says that the state can in fact enforce this law. Interestingly, Colorado officials then come back, of course, and say that the anti-discrimination law here, it does not require the website provider to do anything, doesn't require her to affirmatively say anything. She simply can't advertise the fact that she is not servicing same-sex couples, nor can she advertise her own views about faith. which leads to what the Supreme Court, how they define this case. They basically say that we're going to be reviewing whether or not so much the religious aspect of this, but the other part of the First Amendment, which we did not talk a whole lot about, which is the free speech right. And so on December 5th, just a few months ago, the Supreme Court in this term, those justices you just saw, entertained oral argument on this very issue, and they're determining whether or not the website provider and her exercise of her religious beliefs overcomes the right, the obligation, if you will, of the state of Colorado to enforce its anti-discrimination law. And once again, raises this issue. Where do you come down? Reasonable people can, in fact, and have, in fact, disagreed on this. You may recall way back in 2018, may say, well, gee, I remember this before. Yes, indeed, it was before the Supreme Court, once before, also out of Colorado, also the same statute. Jack Phillips, he was not a website provider, he was a cake maker. Remember this case? And he also decided not to service same-sex couples. The Supreme Court ducked the issue at that time and said, we're not going to decide it. We're going to send it back to Colorado because we don't like the way that the Colorado authorities treated Mr. Phillips in adjudicating his claim. They never resolved this, if you will, this conflict under the Colorado law about free exercise and government involvement. But now it's back. And in June of this year, in this case called 303 Creative versus Elenis, watched by an awful lot of people, among the other 60 or so cases the Supreme Court is deciding this term, the Supreme Court's going to tell us once again what it thinks of the Establishment Clause. Can a state government do this? Prohibit someone from articulating their religious views and exercising their commercial views based upon their religious beliefs? Or does the business person, in this case, the website provider, does she have the right, overcoming the state statute, to exercise her faith as she does and not service same-sex couples and also advertise about that? Finally, one thing that happened just last week, again, gives you some indication of how the Supreme Court is interested in this entire area. This happened just last week, 2014. Again, Pastor Michelle invoking tonight, once again, the horrors of gun violence in America. 2014, a drive-by shooting in Ocala, Florida. And in the wake of that, the government, as we often do these days, organizes a vigil. And that includes not only members of the community, but also police chaplains. And they pray and they sing and they organize much of the vigil around religious focus. It is multi-denominational, it is interfaith, but nonetheless, there are people there, the plaintiffs, who identify themselves as atheists, and they say that they were aggrieved by this and they attended this, and they said that violates their right to the exercise of their own religion. It violates the First Amendment's Establishment Clause. Why? Because, as they said, government here, the city of Ocala, is basically introducing religion into a government operation, a government event. That, they maintain, is violative of the First Amendment. And just last week, the Supreme Court took a look at this and said, you know what? We're going to send this back. We're not going to decide this case. Justice Gorsuch says he joins the majority, which is not a complete majority. Justice Thomas once again says, no, I would have taken this case. But Justice Gorsuch says that there's no need for the court to become involved in this at this juncture. And so the case, yet unresolved, sends it back on what's called a standing basis, basically finds that at least one of the plaintiffs, atheists, does have a right to make the argument. Whether or not he or she will be successful, we don't know. But you can make the argument. The Supreme Court, kind of a victory, if you will, for the Establishment Clause of folks in that area. But Justice Gorsuch along the way says, almost every government action offends somebody. You can't always run into court to get redress of grievances. But again, just last week, the Supreme Court doing that in another case that may in fact percolate up once again. If you are interested in any of this more detail, again, this has been a wild ride through some of this. I recommend any of these particular websites. I'm particularly attentive to Ballotpedia at the very end there. It is not an official site of the Supreme Court, but is very reliable and gives you an awful lot of sense of where these cases are, the oral arguments on them, and it also publishes decisions. You can see all these decisions on the Supreme Court website. You can listen to the oral argument, including the one in 303 Creative versus Elenis from just back December, by going on the Supreme Court website, just in the top there, and pulling up the recording of the Supreme Court argument back in December. You can listen to arguments live as they happen. And yes, indeed, now somewhat post-academic, if you're in Washington, D.C., you can actually go there and go into the Supreme Court courtroom there and listen to some of the arguments live. I am delighted, once again, to have done this very, very quick examination tonight of the intersection between the Establishment Clause and the Free Exercise of Religion Clause, understanding once again, it is necessarily superficial. I suspect fully that you've got lots and lots of questions and comments, and I would be delighted to begin, probably imperfectly, to address some of those right now.
Okay, so again, if you could use the your raise hand function down by your reactions there, if you have a question that you'd like to put to Attorney Santelle.
And David, if you can help me also, my screen shows many people, but not everyone. So if there is someone who's raising their hand, you could call on them. That would be great for me as well.
But I think you may want to stop sharing your screen at this point. I think that would also help a little bit.
Let's do that as well. There we go.
There you go.
Okay, good.
So you got Penny there.
Okay, Penny, go right ahead. Your comment or question.
I think I understand the idea that in Maine, people have a choice to send their children to a religious school. My objection is I don't want my tax dollars supporting other religions, especially some which I have strong feelings against. So what about my right not to monetarily support them?
And Penny, you have just articulated exactly the view of Maine. They say, if you lived in Maine, they would say Penny Robinson gives us tax dollars, and we are obliged, because of what we do, to apply those in a way that does not inhibit, but that does not encourage any religion. And by virtue of giving monies to a family that places its children in a private religious school, you're effectively taking Penny's money and supporting a religion. You're doing exactly what you just described. The upshot, and this is not a satisfactory answer to your very good and more than rhetorical question, Penny, is that's what Maine maintained. And that's what the Supreme Court has said is not violative of the law, that basically what you are describing here in your frustration is that the view of the Supreme Court is that's discrimination against a religious entity. And if you're going to apply the monies to private schools, you've got to do it to religious schools as well. I'm not saying I agree with that necessarily, but that is the opposite view. And that is also the view of the case, again, coming out of Montana, the state-sponsored scholarships as well. Likewise, tax dollars supporting a state scholarship for students, where are these used? At religious schools. The line, I think everybody would say, is necessarily blurred, and it underscores this notion of lack of a clear defining principle here. Your objection, Penny, is not only well noted, but an awful lot of people who argue this before the Supreme Court, at least 3 members of the present Supreme Court, also agree with you strongly.
Thank you.
And again, that Penny, I appreciate that very much. Cindy, you've got a question as well, I see.
Yeah, I'm just wondering, how do they not understand that is not separation of church and state? That just totally confuses me.
Yes. And so the other thing that I would recommend is just this. Again, I've done this very superficially. I will tell you candidly that as even I read these opinions, especially with, the big thing I would say, Cindy, about your special comment is under the Lemon test, which we talked about, and this entanglement concept and the abandonment of that test, which gave us guidance, at least, again, it resulted in different outcomes. But by abandoning that and looking into history and then also substituting this notion of discrimination, it does seem to give us a lack of a standard and doesn't give us clarity on how these things are to be interpreted. I agree with you personally, once again. The other thing I would recommend that when it comes to the decision, again, Carson versus Macon, pull it up. I can send it to you also if you'd like me to do that. And you can read it, and you can read the majority opinion. focusing on the discrimination that they feel is happening by virtue of what Maine is doing. And then you'll see the very strong dissent by 3 justices, including Sotomayor, saying, no discrimination. Fundamentally, you're turning back 240 years of history, and you're eliminating the fundamental principles of the First Amendment that do, in fact, separate church and state. So your frustration, again, like Penny's, well taken, I think, well noted. Right now, for good or for bad or something in between, a majority of the Supreme Court does not agree with us. And they have, again, just as this past June, substituted a new test that takes away the analysis that you and I and others in this group tonight would probably apply with a great deal more clarity and understanding.
As we're waiting, I have a quick question. Recently had someone talking to us about the fact that sometimes people of faith, kind of on the progressive side of the ledger,
Yes,
are so concerned about separation of church and state that they don't feel that they have the freedom to kind of express their moral indignation that arises from their faith at matters that are in the political arena. How would you address that? Like, you know, I mean, what is, faith leaders and faith groups like ours kind of stepping up and actually taking very particular stance on issues?
right. And I think, and isn't that one of the great challenges of our time, right? That all of this is obviously dependent upon thoughtful, good, decent, reasoning people. Again, some of us disagreeing, of course, that can happen. But how important is it, David, for groups like this and others, people of faith, people who do have religious affiliations, to say that, as Penny has, as Cindy has, and others, I'm a person of faith, and I believe in something beyond myself, of something spiritual and something religious, and I've got something outside of my own, and that prompts me to be active in the world and focusing on community issues. And even in the midst of that, and perhaps because of that, more accurately, I feel strongly that government should not be doing this, or government should be doing this. The mere fact that you are a religious person, I would say, not only should not prohibit you from being very articulate, but gives you, to my mind, special reason to be very articulate, right? The thing we haven't talked about tonight in the First Amendment is free speech clause, which follows religion and the separation of church and state right after what James Madison wrote there. I think that for the Supreme Court, for the United States Congress, for our legislature in Madison to have a full understanding of the issues, with respect to this last case, for example, it should not be simply the atheists or the agnostics who are advocating for these things. It should be people of all faiths, of all levels, of whatever your particular internal moral code, your spiritual code, whatever your inclination may be. You need to be heard, to make it clear that, first and foremost, you're people of reason, and that your spirituality is a part of you, as is your commitment to the Constitution, and all these things. They're not mixed up. They're all part of the same basic mindset. And to hear from people like you and others who articulate this concern, well, I don't want to be heard too much because that's imposing my particular moral view, my religious view. Just the opposite. It is because of that our government leaders need to hear from people who are affiliated with a religion, have some spirituality of their own, maybe not be affiliated with a particular church or spiritual group or faith-based entity, but nonetheless feel about this so strongly and identify with free exercise, and nonetheless say that government should or should not be doing this. It's not really answering your question. I'm going to say that their advocacy should be clear because of who they are and how they live their lives. Government's got to hear from you.
Amanda, I think yours will be the last question before we have to move on.
Okay. I'm going to pick up on Lisa Jones' question in the chat, where she had asked, what impact has the Federalist Society had on reshaping the courts? Jim, you worked in the federal court system, in the US District Attorney's Office, all for 30 years almost. or maybe it was 30 years
Right,
plus.
right.
And I'm wondering if you do have some feelings and comments about the federal judiciary and the changes that you have seen with the increased politicization. That's not the correct word. We'll say the increased divisiveness of
Mhm.
politics and what's happened in the United States Senate, which is where federal judges get approved.
Right.
And whether you have any comments generally on the evolution of the federal justice system over the last 35 to 40 years.
Yes, absolutely. Again, as you could well imagine, I could wax on for 20 minutes about that very, very thoughtful and good question. I'll say just as a preliminary matter that again, this dates me, but you should know that the Federalist Society was initially organized by my classmates at the University of Chicago in 1982. David and Leah, my classmates, went off one night and said, we're going to put together this group of people who are going to be advancing, I will use the word conservative, judges and justices, and promoting a very conservative, non-progressive view. They recruited as their first faculty advisor a fellow named Antonin Scalia, who at that point was a professor at the University of Chicago, went on to be an appeals court judge in the District of Columbia Circuit. And then, of course, as you know, for 30 years until his death not too long ago, was on the Supreme Court. So there's a special focus that I have on this. My own view is, again, it is my view, that the Federalist Society, because of this sort of single-minded approach, that is that we are going to be advancing the candidacies, the applications of judges and justices who have a very, very, I think, narrow view of the Constitution. And again, we could talk about that for great length. That narrow view being articulated right now, last year, this year, in this incredible focus, not upon standards in the area of privacy rights, and even the area of firearms, environment, education, the capacity of the president to act to keep us safe and secure during the pandemic, and immigration issues. All of those things, again, in prior times, in my lifetime, I think the lifetimes of most people here, would be the subject of disagreement, but not based upon an ideology that is unwavering. Be based upon an analysis that looks at the facts and the circumstances today. And one of the things that the Federalist Society has done, witness the elimination of the Lemon test and this focus on history, is to say, we are going back to originalism, which is Antonin Scalia, textualism, which is also him, and we're not going to determine whether or not this particular event in the area of religion, or the application of environmental law, or the application of an education principle, whether that makes sense today in 2023, when you look back to history. And if indeed in the time that James Madison wrote the Second Amendment, or wrote the Eighth Amendment, cruel and unusual punishment, Sixth, Fifth, all those amendments, the Constitution generally, what did they think? And that dictates what it is should happen today. That is the big movement that the Federalists, yes, and there are at least 4, if not 5, maybe all 6 of them on the Supreme Court, was ascribed to that Federalist view. And yes, indeed, on a regular basis are appearing in Federalist meetings and discussions and conventions to affiliate with that. That's the great, I would say, the danger with a small d of that intrusion of Federalist views into our Supreme Court. It eliminates a focus that is premised upon 50 years of developed standards and practices by justices, once again, on all sides of the political aisle, but it focuses always on the 1960s, the Voting Rights Act, Housing Act, Civil Rights Act, all premised upon an analysis of what's happening today and balancing back and forth, not this simple focus on the past and history that got us Dobbs, that got us Bruin, and that may in fact get some other decisions here as long as the Supreme Court is in place. It's also animating dramatically, of course, the selections being made not by this administration, but by a prior administration, also a future administration, because it's fairly clear that one of the tests to get your nomination advanced to the Senate is whether or not you ascribe to these principles. As I say, plainly, you've got at least 5, if not 6 members of the Supreme Court
who would ascribe to what the Federalists will say. The one positive additional thing I'll say, and then I will be quiet, is that there is also a group on the other side that was created in response to the Federalists. The American Constitution Society also sounds very patriotic. They advance liberal advocacies and liberal candidates, not with the venom, if you will, that I think sometimes the Federalists do, and I don't mean that in a really bad sense, but not with the strength, but they're advocating for rational, reasonable approaches to all these things. And so there is this other group out there that's also trying to balance those scales, but it has had a dramatic impact upon our judges, Supreme Court, Appeals Court, District Court as well. The Biden administration plainly goes in the opposite direction. This is why, last comment I will make, and then I will be quiet, is this is why, where do you get federal judges? You get judges through voting, right? How does that happen? You vote for a president who nominates federal judges, and you vote for senators who confirm federal judges. And that's how you get changes in the Supreme Court and the appeals courts. And that's how America changes or not.
Thank you very much. That was a lot. That was we picked up a lot from you tonight. So thank you very much for this very thoughtful presentation.
David, once again,
And with that,
I'm
we're going
delighted
to
to be with
pass
you tonight.
we're going to pass the ball over to Peter Bakken from the Wisconsin Council of Churches. We're going to do our call to action, and then we're going to get into small groups for a few minutes to say how it is we're going to respond to that call.
Thanks, David. And I'm very grateful for Mr. Santelle's strong endorsement of faith-based advocacy, because that's what I'm going to be invoking in this call to action, but in a different direction toward two different branches of government, not the judicial branch, but the legislative and the executive in our state. As you know, the governor introduced a proposed budget, and I'm going to be putting some links in the chat that will follow my remarks. But the first one has some information, is where you can get some good information, and probably more than you want, about the governor's budget. But the governor's budget message would be a good place to start. And he's calling for investments in a lot of things, from mental health to expanding Badger care to tax credits for lower and middle income workers, driver's licenses for undocumented immigrants, returning 17-year-olds to juvenile justice system, a whole range of issues that are of concern to the people on this call. Now the joint finance, now that the governor's introduced it, the ball is in the court of the legislature, and specifically in the Joint Finance Committee, which is made up of members of both parties, but very much more made up of the Republicans who are in the leadership and the majority. They have indicated that they are basically not going to pay any attention to his budget. They're going to go back to base, which is to say the existing budget, and then write their own from there. But we do have an opportunity now and an obligation to speak up. The governor's budget gives us a platform for talking about those things that we like, what we don't like, or what else we should be in the budget. So even though the budget, as the governor introduced it, may not go anywhere, this is an opportunity for us to lift up some of those provisions that are important to us. And one place that we can do that are at the budget hearings. All of the budget hearings this time around are going to be in person. Last time there was a virtual one. There isn't in this case. There will be 4 in-person hearings: April 5th in Waukesha, April 11th in Eau Claire, April 12th in Wisconsin Dells, and April 26th in Minocqua. If you can't attend any of those, you can still use the Joint Finance Committee's portal to submit your comments, or you could email the Joint Finance Committee. You can also, it's also worth talking to your own legislators. From what I understand, every legislator has what's called a budget buddy. There is one of the members of the Joint Finance Committee that they can communicate with, and they can relay your concerns, your what you want to see in the budget to their budget buddy on the Joint Finance Committee. And again, you can find in the chat the link for the Joint Finance Committee website, which has the information about the hearings, more details, the portal. And then there's also a link where you can find your own legislator to reach out to them. And if you are going to one of the hearings, there's a great short tip sheet for testifying from the Wisconsin Interfaith Voter Engagement Campaign. And that'll give you some guidance on that. But I do want to really return to the question, sort of like, why bother? Sometimes if the Joint Finance Committee is not necessarily going to take up the governor's budget or take up the things that we're interested in, why speak out? And I think the important thing to remember is if we don't speak out, other people will. And there are people who may have, very diametrically opposed views on the direction that the state should go, what's the right thing for the budget to invest in or not invest in. Silence gives consent, and I don't think we want to do that. We want them to know, both the public at large and our legislators, that their position is not necessarily the only position, that there are a variety of views out there, and it needs to be taken seriously. So we need to make some noise in that regard. And it's also the fact that once you get into these areas and you're making your own comments, you're also, listening to other people. You're listening to their arguments. You're listening to their concerns. You're listening to their experiences. And that's important to know, so that you know both how to respond when you have the chance to talk to people on the other side of the fence, but also to, think about your own position. And if there's any way that you need to take it into consideration, because you can't expect other people to change your mind if you're not willing to change your own mind. And finally, just the budget is a statement of values about the kind of Wisconsin that we want to be. And so this is our opportunity to talk about what we as people of faith, as people of conscience and moral values, the sorts of decisions we think our legislators should be making. And so, it's a good way to demonstrate a healthy way that people of faith can operate within the public sphere. So we're going to go into our breakouts now. I guess I'll let David give the prompt question, but it follows from what I've just said.
And yeah, you're going to just have a few minutes, and you're going to be in a small group and introduce yourselves to each other. Take all the things Peter just said about the state budget and things, and say, what are you going to do about it? What can you, if each of you just kind of discuss, what can you personally do? Can you go to a Joint Finance Committee hearing? Can you contact a legislator? What can you do to do it? And Rhonda Lidner, who's going to do the closing prayer, is from Wivik, so she can answer your question, Kelly, when she comes on. She can tell you what she does. So you got about 8 minutes. You're going to be 4 or 5 people to a group. What is it you can do to be sure that your values are heard by those crafting the state budget? Welcome back, everyone. So before we meet again, which will be on April 11th, the next one of these that we have, we actually have a very important set of decisions we're going to make in the state of Wisconsin. And Lisa Jones from MICA is going to talk to us, give us a bit of a reflection about voting and about our role in this election season.
All right, thank you, David. As you heard, If we want to change the culture in our governments and systems, we have to vote. We have to vote, and we have to have our children who the culture of voting passed on from generation to generation to generation. Because if we don't, this kind of stuff is going to continue. And unfortunately, the country, as we move forward, we will take 5 steps forward and take 7 steps back. And I think that many of us would agree that we're feeling, how many steps back have we taken? So that is why that voting is so important. And I remember from Pastor Ellwanger, he always reminds us that it was voting when Black folks got out and voted in droves, that was what put the nail into Jim Crow. So we have the ability to do that. We have to make sure that we are getting out our voting efforts. I have on my little t-shirt, unlock the vote, my unlock the vote t-shirt. So, you know, and it's on us to be able to do that. And keep in mind that we think that everybody votes in our congregations and in our circles. These elections traditionally have been abysmally bad. So it's not just people in Milwaukee, it's people in there are probably people in your congregations and organizations that are not voting in some of these elections that are not presidential or for governor. So please make sure you do the outreach for all of them. Another reason why we need to be concerned about voting is we have 3 things that are on the ballot that should be of concern to people of faith. And as someone who is working to reduce the incarceration rate in Wisconsin, there are 2 questions that are on the ballot that have to do very specifically around there. One is around cash bail is one of those questions. And the other one is around conditions of release before conviction. And I'll tell you why these are not great ideas to be on they shouldn't be on the referendum as a question anyway. But the way the questions are worded, it leaves, it's very ambiguous on even defining some of the terms. So the legislation proposes to delete the word bodily harm. We're talking in the conditions of release, without properly proposing that what the term serious harm is. And it leaves us with this ambiguous language. And so the concern is, by leaving this language very ambiguous, the concern is it's going to increase the disparities in the treatment of folks of color who are already incarcerated at high percentages. And so sometimes when we think of these referendums and the way they're worded, it just is going to make things worse. So then there's another question about the about cash bail. Again, it's really concerning about why we are even talking about cash bail. We understand why it's coming on the ballot with the case in Waukesha and things like that are happening, but we already have things in place. And so these on the ballot potentially could be devastating, particularly for people of color and especially Black folks. There is another question that is on the ballot that is of concern, and it has to do you believe that people on welfare, let me read the question. Shall able-bodied childless adults be required to look for work in order to receive taxpayer-funded welfare benefits? Well, I don't know about you, but how often are we using even the word welfare in our I mean, I thought welfare went out the window of what we thought as welfare back in the Clinton era. So the way the question is worded, it seems very one-sided. Of course, people don't, most people are going to go the way they're going to answer it. But even the League of Women Voters has taken an opposition statement regarding that. And so when we're looking at these referendum questions, they're going to impact all of us. So when we're going out to vote, voting for the candidates of your choice, but then also too looking at the referendum questions and seeing how they are going to impact people across the state. And so please make sure you work to get people out to vote. Vote like your life depends on it. And it depends, and for other people, it's a real big thing, because we don't want the incarceration rate to go up any higher than what it is. I turn it back over to you.
Thank you. And after all that, it's good that we wrap up with a closing prayer from Rhonda Lidner of the Wisconsin Interfaith Voter Engagement Campaign, or WIVIC.
Thank you. So I have a prayer that comes, a traditional prayer at first, and then a more modern prayer from the National Council of Jewish Women. It starts out, Baruch atah Adonai Eloheinu melech haolam asher kiddushanu b'mitzvah tov v'tzivanu l'dor tzedek. We praise you, eternal God, sovereign of the universe, who calls us to holiness through mitzvot, commanding us to pursue justice. God of our ancestors, we affirm that you have created each of us in your sacred image, endowed with the inherent right to dignity and autonomy. We ask that you guide us towards a caring and loving community and nation that reveres the dignity in each of us. We ask that you endow us with the strength and resolve we need, because the path that lies ahead is challenging, and we all need resilience, strength, and courage. We ask that you protect the most impacted and marginalized among us, because it is they who are most at risk. We do this work in your name, God, because we are the compassionate, loving creations of a compassionate, loving, and just God. This is indeed holy, sacred work. Amen.
Amen. Thank you very much, Rhonda. Thank you again, Mr. Santelle, and everyone else for being here and for participating. We'll see you again on April 11th.
Thank you, everybody. Have a wonderful night.
Bye-bye.